Finally, we submit.
Okay. I was thinking that my colleague Shazza was going to say something. But let me start with if whatever wants to add, you can add. But
the last one submits to
yes. Okay. Now we are on. Let me start first of all by asking that let me request that the court, first of all, Your Honor, grants bail to the accused. I mean to the respondent to this matter. Please grant me. And I'll be requesting the court very humbly to do so. Why am I saying this, Your Honor? It's because now I believe that once they have come under Article 49G and 49(1)H, they have an obligation to give you compelling reasons. It's an obligation. It is nothing less than that. Your Honor, if then they have failed in that particular point, what then becomes of that article? Doesn't it become absolute once they fail? And I'm saying they have failed at least miserably today. Why am I saying this, Your Honor? Because if you look at Article 49, and this one was also in the Republic versus Oyama of case, the court has indicated what is supposed to be a compelling reason. That's in paragraph number 23. Tushapatia mengi mkonazo mpaka tumechoka, sio? What does the court say something to do with compelling reason? And this is the Court of Appeal decision in the Oyama versus Republic case. It must be something that is forceful, something that is so convincing, something that is so strong that the court cannot ignore it. Cannot ignore it. Now, Your Honor, once you have seen that, then the state has come and told you they want the suspect or the respondent to be in custody because they want to investigate or they want to have access to his phones. What they did not tell you is that he gave them the passwords and they're keeping quiet about it. And if they want the password, we can give it here in court now, so that that point, ya kutaka simu, is out of the window. Let's finish that one. It's a simple thing, a 1-minute thing, doesn't need 21 days. They tell you that there are CCTVs that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DVI. That is the most important one. So what they have there is a shell. And that's the reason why they can't pick it. And that's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. Then they're telling you they are going to interfere with the investigations. But in his affidavit and what he has said here on oath is that, in fact, I've given you a password. Pick a password. They're telling you.
So you don't have to take it, eh?
Yes, Your Honor. The issue is not about the SIM or the password.
Yes.
It requires a lot of things.
No, okay.
Your part is special. Watching me. I'm running the show now.
Okay.
Yes.
Now they are telling you about witnesses. They are not telling you in the affidavit which witnesses, but they are telling you something else that is imaginary, that they are yet to get some other witnesses who they are going to record their statements. What does that show you, Your Honor? That the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail to an accused person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of the respondent here. When the IO here called him, did he appear? Yes. When he was told to go and record a statement, did he appear? He did, and recorded a statement under inquiry. When the DCI director himself spoke and made some wild allegation in Parliament, the OCS woke up by himself and took himself to the Gigiri police station, headquarters CAT, and asked, do you need anything from me? Look at this kind of person we are talking about. Do you need anything from me? Then they arrested him. Why would you deny him bail, Your Honor, when such a person has exhibited a person who is capable to cooperate and even volunteers before they get those Subarus to go and pick him? He volunteers. So today, we are talking of a person who knows the law and respects it. Those are the grounds that they had for you today, Your Honor. So what else remains? Now let us go back to that issue of the litigation. Then have they convinced you, Your Honor? And I'm saying they have not. And that is why I will agree with my learned colleague that if you gave him a cash bill of 7K, that is fine. In fact, for me, I'd say pre-bond. Because at the time he was going to those officers, he was okay. There was no money, there was no cash bill, but he went. That shows a person willing to come to court. They quote Article 19, they quote all those articles in the law. But you see, Your Honor, today, let us agree. Why do we have these fundamental rights? It is so that we can protect this kind of person from this kind of people. The police. That is why you have these fundamental rights. And Article 19 is quite clear, and it's my favorite, that these fundamental rights, who do they belong to, Your Honor? They belong to an individual and not the state. Not the state. Once they know that those fundamental rights exist, they come to Article 20, which is very clear and says it binds all state organs, including the court, including the prosecution, and including the officers, the police officers. That includes also IPO. If it includes them, today they come with an affidavit and tell you, denying bond on very flimsy grounds. Did they read Article 21? I am certain that they ignored it because Mr. Whitty, my friend here, would have told them. And I don't know why he's not telling them, but Article 21 is clear that when these fundamental rights are known to exist, all these arms that I have mentioned, what are they supposed to do, Your Honor? They must start by wanting to grant this fundamental right. Article 20, sub-article. Might start by wanting to grant to ensure that this person enjoys the fundamental right. But they still give you this affidavit. So what do we do, Your Honor? Article 22 is clear. Once we have noted that they are in a position where they want to prevent an enjoyment of these fundamental rights, we come under Article 23 and Article 165. Very clear articles. So that the court, once it has noted this kind of can I call it, bad faith application, we'll be able to see. Let me qualify it to say, why does it come under bad faith? You have an IO who has come to court today. What does the IO do? Refuses to answer questions. Just he will not answer that. He will not say anything. He doesn't know anything. He doesn't even know who his boss is. And he doesn't know whether he attended a press conference. Now, things that are in public domain, and we know them by ourselves. Why should you believe him today? That once you release this person to him, he shall be treated well. Why? You cannot believe him because he denies publicly even his own boss. I know now how Jesus felt when Peter just and then, Yona, if that is the position, and then they come and tell you, oh, this, the public order and issues like that, and that the safety of this person depends on them keeping him in custody. Where does that come from? Because Article 29 is clear. This gentleman must enjoy his fundamental rights. The security, it is provided by the state. It is guaranteed. Guaranteed. So they can't come here by a mere application and tell you that he cannot be safe. And they don't quote that article in their application. Why? They avoid it intentionally because it is black and white and it is clear. So, bad faith again from the investigative officer. And he is my friend.